breaking news in the Guns Save Life case out of the state of Illinois, specifically a Second Amendment challenge to the state's firearms owners identification card program that says you cannot possess or own a firearm in that state without a state ID card. There was a Second Amendment challenge to this. A state court judge in that state, a trial judge specifically, has upheld the law. But I'm anticipating an appeal. Let's see what happens next, but we're going to talk about it when we get back. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun and constitutional attorney, member of the U.S. Supreme Court Bar, and author of the brand new best-selling book, Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms, available on Kindle and in paperback and on audiobook. And don't forget to follow us, not just here on this YouTube channel, which I'm encouraging you to subscribe. We're trying to build our base. Also, make sure you check us out on Twitter at Four Boxes Diner, where I get more Second Amendment information out there as well. All right, folks. So today, Judge Jennifer Ashler, in the central part of Illinois, a state trial judge, has issued an order that says that the state's firearms owners identification card program that says you have to get one of these ID cards before you can possess a firearm, that it's constitutional. She did a full-blown analysis under the Second Amendment in the Nysurpa versus Bruin case, and I would say tried hard but got it clearly wrong. But since she's a state court trial judge in Illinois, I'm not going to beat her up too much because these are not the sorts of cases, I suspect, these high-end constitutional cases, that is her bread and butter out there. So with that said, we're just going to walk through and point out the errors that she made, and then we're going to carry on with that and talk about what might happen next. Specifically, the name of this case is Guns Save Life versus Brendan Kelly. This was a cross motion for summary judgment for you legal geeks out there. They both cross-moved for a judgment. Judge Ashler took a look at this case and did apply the Second Amendment and the Nysurpa versus Bruin decision, but of course, she did make mistakes. To begin with, she was correct in the sense that the plain text of the Second Amendment was implicated by this because, as she noted in her opinion correctly, because this impacted the ability of someone to have a firearm, whether it be for self-defense or to carry or not, it doesn't matter, because it implicated the right to keep, which means to possess, and the right to bear, which means to carry, because it implicated that textual right of the Second Amendment, the Nysurpa versus Bruin standard or methodology kicked in. Now, as you know, the Bruin methodology is really the Heller methodology dumbed down to some degree for judges so they can get it right, because a lot of lower court judges were screwing up the Heller test or the Heller methodology. That's why we now call it the Bruin methodology, which is really just the Heller methodology laid out in a paint-by-numbers fashion for lower courts to follow. And that's what happened here with Judge Ashler here in the Central District of Illinois. However, there's a few mistakes that she made, and we'll get to the specifics in a second. The first is, obviously, if you go back to the founding period of 1791, there is no historical tradition of requiring anyone to get a license to be able to possess a firearm. That simply did not exist. So therefore, there's no analog law. Because remember, it's not about history, folks. The Supreme Court is not interested in a history lesson when it comes to understand our Second Amendment rights. When they say that the text is implicated of the Second Amendment, the burden shifts to the government. When the burden shifts to the government, it's up to the government to come forth with analogues that show that at the time of the founding, the modern-day gun control law was consistent with the long-standing historical tradition of firearms regulations of actual laws on the books and actual laws that were enforced. And that's key. Here, there obviously, at the time of the founding, there were no licensing regimes at all. What to speak of. So what she did was, rather than saying, well, there's no licensing regimes in 1791, she then reached out and tried to cherry pick in a way, various laws that were on the books, none of which were frankly analogous, but she did say, well, there's these gun regulations on the books in 1791. I conclude they're close enough to allow the state of Illinois to simply, to do this. But keep in mind that even today in the 21st century, this Illinois law is the extreme outlier. The last I checked, I think there's maybe 2 or 3 states at most that have these kinds of laws. I think it's Illinois, Massachusetts, and I think New York State when it comes to handguns. But these are so few and far between, even in the 21st century, to require someone to have a license to actually possess a firearm, that this is not just an outlier law from the 18th century or the 19th century or the 20th century. It's an outlier law even in the 21st century. Nevertheless, Judge Ashler went out there and claims to have found some analogs at the time of the founding in American history history that somehow justifies this, but I don't think any of that is true. I do want to make one observation that a lot of people on this channel and other places have made the observation that, Justice Kavanaugh in the Supreme Court seemed to indicate strongly that quote-unquote shall issue carry regimes are constitutional. As you all know, there's two general types of carry regimes now in the post-Bruin world. You have what's known as permitless carry, sometimes referred to as constitutional carry, that says that you just get to carry the gun as an American citizen and your gun permit is effectively the Second Amendment. That is the permitless carry regime. We now have 27 states that allow carriage in their states without any kind of a license. Then you have what's known as a shall issue regime that says that once you meet an objective, I repeat, an objective, non-discretionary standard, very basic stuff like you've not committed a felony, you're not a prohibited person under 922G under the federal statutes and so on, you get to carry your gun in public under a shall issue regime. Now, the Supreme Court specifically said in Bruin that that case itself was not seeking to knock out or analyze in any respect shall issue permanent regimes. In fact, one could even argue that they basically said, well, we're kind of assuming these are okay. But remember, as you know, there's something known as presumptions and assumptions. When a court says something like we're presuming it's okay or we're assuming it's okay, they're not deciding it. They're doing what is known as dicta. Dicta is just some language that helps explain stuff, but it's not the central holding of a case. And when something is not the central holding of the case, it means that the dicta in that opinion, like in this case involving the sort of the shrugging out, the shall issue regime seem okay to us, but they could be abused, and they might not be okay. That is dicta. That is not finding that they're okay. It's just saying we're presuming that they're okay. But as you know from criminal law, for example, if you are presumed innocent, you can still be found guilty of a crime because you are presumed innocent in a court of law, but that just means that the burden of proof in a criminal case to show beyond a reasonable doubt that you committed a crime is in full force and effect, which means, of course, that a presumption that it's constitutional doesn't mean it is. It just means we presume it's constitutional. That presumption can be rebutted and overcome, just like a presumption of innocence can be rebutted and overcome in a criminal case, and people go to prison even though when they go into court, they are presumed innocent. Same when it comes to these shall issue permanent regimes where the Supreme Court seemed to say, well, they might be okay. We're not going to get into it right now. We don't need to fight about it right now. We haven't briefed the issue. That's all they're saying, that at most they're saying they're presumptively okay, but that presumption can be rebutted just like anything else in the law. And again, before I get to the details of what Judge Ashler said, obviously there is zero historical tradition of requiring, in any relevant time period, right, at the founding or in the 19th century or anything, of requiring American citizens to be required to get government permission for the simple act of possessing a firearm, such as in the home. And remember, and this is key, what Judge Ashler seems to have failed to understand at a big picture, before we get into these analogs and why they're distinguishable, that she used. In America, we are a free society. At least we're supposed to be. The Constitution presumes individual freedom. In fact, the only reason why we give up any rights to the state, i.e. to the government at all, is because we give up certain rights because we assume they are going to take steps to protect our lives and our rights from other violent actors, whether it be foreign invaders by protecting the borders, that's what they're supposed to be doing, of course, or by protecting us against violent thugs, whether it be, wherever they come from, tyranny in all its respects. That's the concept here. The reason why that's significant is, in a free society, we don't have to ask permission to act. We are allowed to act as free American citizens. That's how it's supposed to be. We get to act, and if we misbehave, if we commit a crime, if we do something violent or bad, commit a malum se crime, then we get punished. But the presumption is we're allowed to act without seeking permission from the government. We don't have to go mother may I to the government to act as free Americans with freedoms. That's what makes America America. In contrast, in totalitarian regimes, like the former Soviet Union, like in China today, and other totalitarian regimes around the globe, it works in reverse. You're not allowed to act. You're not allowed to do anything unless you first and foremost go mother may I and seek permission from the government to exercise the privilege given to you by the government to act in a certain way. So I think that going throughout this opinion, Judge Ashler seems to simply have misunderstood that the presumption set forth by Bruin as well, once the Second Amendment is implicated, the presumption is freedom. We have the right to do certain things, and the government bears a heavy burden to overcome that in various ways, including shown by historical analog laws that they've always been allowed to do this, and they simply could not do that in this case. And you'll see why in 1 second. Now, Judge Asher does get one thing right. She does point out that the relevant approach here is text first and then history second. One error she made is she talks about generally history, but it's not about history. Remember, it's about actual historical analog laws and their actual enforcement. So she begins by talking about that there are disarmament statutes dealing with dangerous or virtuous or specifically unvirtuous people. Now, this gets into some sloppiness on Judge Asher's part, okay? This goes back to the anti-gunner view that if you are not virtuous, we get to take away your guns. That's right. That is the official position of the anti-gunners in America. That it is not whether or not you are a violent danger. It is simply whether or not you fail to be virtuous. Because obviously, if you're not virtuous, which is a very high moral standard, well, guess what? They get to take your gun rights, which means if you fail to recycle properly, if you do not drive an electric vehicle, if you use somebody's wrong pronouns, if you swear in public, if you litter, if you jaywalk or you speed 5 miles per hour over the speed limit, that makes you unvirtuous in the eyes of many anti-gunners because you are not respecting the law, and your failure to respect the law makes you not virtuous and they can take away your guns. As opposed to what would be the proper standard, that you are a violent, dangerous thug like Jeffrey Dahmer, and then, yeah, we can disarm you and lock you up. But that's not what we're talking about here. Here we're simply talking about why should Americans who live in Illinois have to get an ID card to simply possess a firearm, which is their Second Amendment right. And there's nothing in this decision from Judge Asher in Guns Save Life that would justify this. First of all, again, she simply tries to talk about virtuousness, which is not the standard, right? Supreme Court has never said that. Nevertheless, she seems to be adopting this. Now, the other thing you see what Judge Asher does, she talks about how at the time of the founding, there were instances where you could disarm people such as Quakers and Catholics and whatnot. Without getting into the nitty-gritty of this, the bottom line is this. Those individuals were allowed to have guns to begin with. Nothing required them to seek permission from the government at the time of the founding to get the guns in the first place. Now, even buying into this historical analog argument that you could be disarmed, that presupposes that you had the guns in the first place and then they took the guns away from you. That is not analogous to, hey, you got to go beg for your guns from the state and get permission before you can acquire the guns. You see, they're totally different, right? One says you can all have guns and it's perfectly fine to have guns. No big deal because you're an American. But if you don't do something right, we can disarm you if you don't do the right things and follow, and become a danger to society in some way. But again, what she does is conflate the issue, and she gets it backwards. She says, well, because you can disarm someone who already has a gun, we can then say you don't get a gun until you ask permission. Those obviously are dissimilar situations because one is asking you to beg the king for your gun. The other simply says you get your gun, and if you misbehave or do something stupid or wrong and become a danger to our society, then we get to take the guns. She's got it backwards, as you can see. The second set of laws that she talks about are militia laws. Now, these are just utterly silly to even contemplate this. Now, let's go back. Let me make this very clear. The militia laws on the books at the time of the founding dealt with how to operate a militia, okay? The militia was drawn from ordinary American citizens, but they're two separate things. The Americans had the right, all Americans had the right to keep and bear arms and to have ammo and to have as many fires as they wanted at the time of the founding. If they were called up for militia duty to protect the public, when they showed up for militia duty, they had an obligation to bring certain things. That's true. But you see the difference. For example, in the Militia Act of 1792, it did not cover all Americans. It only covered those who were 18 to 45 years of age, able-bodied white males. Those were the individuals that had to bring commonly owned firearms with them at the time to militia musters. But everyone else in America still had the right to keep and bear arms. That's why the Second Amendment says the right of the people to keep and bear arms shall not be infringed. That's all of the people. But what Judge Asher does here is she talks all about militia regulations and militia laws, but that assumes that you had to go to militia, and then during the context of militia service, there were certain things that had to be done. But that doesn't apply when you're outside the context of serving the militia as just an ordinary American living your life, including those people that fell outside of the definitions of who was in the Militia Act of 1792. So if you're 65 years old, you could have any gun you want and you didn't have to worry about militia duty at all. But if you're 44 years of age, then yeah, you might have to deal with militia duties. But again, regulations dealing with militia service is unrelated to what you do in your private home. Think of it this way. If I play football and I require you, if I play football or I coach football and you're on my football team and I require you to bring certain things with you to football practice, nothing about what you have to bring to football practice speaks to what you're allowed to have in the home. You can have other stuff in the home, more stuff in the home. You can have 50 football helmets, for example. It doesn't matter. You see the difference? When you show up for work, you may have to have certain things, but that does not speak to what you're allowed to have in your private life in your home. Nevertheless, Judge Asher here confuses those two things and tries to pretend that what you had to bring to work and the regulations associated with the workforce somehow impacted what you had to do in your life. And keep in mind that makes no sense because the firearms owner ID laws in Illinois has nothing to do with militia duty. It's just ordinary people having a gun in their homes or possessing a gun unrelated to militia duty. So these militia laws have nothing to do and don't speak to any issues and do not justify that law at all. And of course, Judge Asher makes the classic mistake that a lot of anti-gun judges do, which is on page 17 of the decision. She talks all about late 19th century laws, but remember, it's not that hard, right? The Second Amendment was adopted in 1791. We looked at 1791 information to try to understand the scope of the Second Amendment because that's when it was adopted. We looked to what's known as original public understanding of the people that adopted it. When you get out over 100 years, everyone that adopted and was involved in the adoption of the Bill of Rights, the Constitution, the Second Amendment is dead. They're dead. So why on earth does a late 19th century views of the Second Amendment have anything to do with what the 1791 understanding is, except to the extent that you can, as a court, use late 19th century historical evidence to confirm or affirm or reaffirm your conclusions of the understanding of 1791 Second Amendment. But what you cannot do is use late 19th century understandings to shrink, to narrow, or to contradict the scope of the Second Amendment itself. You can affirm or confirm it from the 19th century evidence, as the Supreme Court has repeatedly said. You cannot contradict it. And the best, most powerful evidence of this, just in recent examples, is last term, Justice John Roberts, in a case involving another part of the Bill of Rights, also adopted, of course, in 1791, specifically, issues involving the First Amendment, the religious freedom clauses. Justice Roberts rejected 30 laws that restricted religious freedom in the late 19th century as being irrelevant to the understanding of the First Amendment because those laws were not adopted in 1791 when the First Amendment was adopted. So if Justice Roberts rejects 30 state laws in 30 states in the late 19th century in the context of the First Amendment in a religious freedom case just last year, guess what? The same methodology when it comes to the Second Amendment, right? Late 19th century laws that are inconsistent with the Second Amendment, or the First Amendment for that matter, are thrown out as unconstitutional, totally irrelevant, meaningless. Yet Judge Asher got it wrong. She obviously did not read that religious freedom case of Justice Roberts speaking to this very issue. All right, folks, so I suspect the Gun Save Life group is going to probably take an appeal. I'm sure this is going to go on for a few more years. We'll see what happens. This is just step one, stage one. I'll keep you abreast as things develop. I think Judge Asher tried hard, but got it wrong, and I don't think this will be the last word on the question of whether or not these firearm owner ID laws are constitutional. I think they're unconstitutional. I think it will take a few years to knock these things out. I think we will get there, but it's going to take some time because the court system takes time. Unfortunately, that's just the way it is. But in the meantime, if you haven't subscribed to the Four Boxes Diner, please do so, and we'll see you again here at the Four Boxes Diner.
Orders up. Table 2A.